We have people populating in, entering through the front door of the Zoom call. And today we have a really exciting topic, a kind of hot topic as of late across the nation, not only in New England, as it relates to handling toxic, dangerous unit owners, including, handling the tenants, the residents, guests in condominiums, co-ops, and HOAs. And what are you going to do when a dangerous or a toxic unit owner is in your community association, and how are you going to handle it? Again, you could tell we were kind of chit-chatting a bit about this topic right before people started walking in. Or I guess entering virtually in, and we were just talking about no set of facts is going to be the same. So again, that's kind of a good segue into our program, the 16th version of the Marcus Hour, featuring Stephen Marcus, Jake Marcus, and our special guest today, someone who is a law firm member at Allcock Marcus, Norm Orban. Norm, any opening remarks?
No, just excited to be here on my first experience on the Marcus Hour, and just kind of looking forward to what should be a fun webinar. I will say to the audience, I am stuck working from home with a 4-year-old, so you may see a head pop in from time to time, but I think he's pretty content in the next room right now.
Jake, you want to give a quick pitch for CAI? I know it's not a CAI program, but
yeah, absolutely. I think that's a good idea. So a pitch for CAI, which is Community Associations Institute. That is the go-to source for all things community associations, condo, HOAs, co-ops, whether you're a unit owner, property manager, board member. It's important to get involved with CAI as much as possible. We've been involved with them for years, and it is a great organization to kind of, do educational things like this, you get the right resources, all the above, and kind of just be able to really get a group effort. And if there's a problem at your association, it's likely that someone has dealt with something similar, hopefully. But if you need any resources, CAI has plenty of resources to help you out there. So CAI New England, Claudette Carini is the chair. There's branches throughout the nation where members of as our firm is located in numerous states: New Hampshire, Maine, Rhode Island, Massachusetts, and Florida. We are also members of CAI Florida, which, I may from time to time mention Florida. I'm licensed in Florida and Massachusetts. There's a lot of things that relate to how Florida handles things that may come up during the program. The reason that's important is because a lot that happens in Florida ends up either making its way to New England states or is good guidance or best practices for other states. So just something to note. Don't brush it off. It could be important, even if it's just best practices or guidance. And again, that's something. This is a informational, educational webinar. It's not to be construed as legal advice. Every set of facts is different. If you have specific questions, go to your attorney. And that could be us. It could be Allcock Marcus, a full service law firm that represents community associations in New England states, Massachusetts, Maine, New Hampshire, Rhode Island, and Florida. Well, Florida is not a New England state, but we consider that New England South. And we are happy to help with any questions that may come up. So today, again, we have Norm, myself, Stephen. Stephen, anything you want to add before we get started?
no, I was just going to say for a little more on CAI for the New England chapter is located in Wellesley. Maybe Claudette, our executive director, who does a wonderful job running this nonprofit. Her email address is ccarini, CCARINI @CAINE.
Let me put that in the chat.
Okay, perfect.
CAINE.com.
.org.
Okay.
Yeah, and shaking out. Also, despite Jake's disclaimer that we're not giving specific legal advice for anybody, and it shouldn't be construed that we are, because we would need much more facts and information and to read your documents for a particular case. He doesn't mean that you can't put questions into the Q&A or chat. And if we'll either try to answer them during this webinar, or Monday or Tuesday next week, you'll get the PowerPoint and a copy of the video, or a link to the video. But we also try to respond to all questions that were asked. Some were asked before the webinar. So we try to respond to all of them. So if people didn't sign up, anybody who registered sees it, or if anybody has to sign up early, or for those questions that came in before today.
So let me tell you, we're going to get to the program now. It's a very important topic. Can be alarming topic. You can feel, a little bit, what's your responsibility as far as, a board member, a property manager, as a fellow unit owner. How do you deal with the toxic or noxious or obstructive unit owners? Now, I heard a stat recently, or everyone says I heard a stat. It's probably made up. 90% of stats are made up, but I think the stat was like 95% of complaints are going to come from 5 to 10% of unit owners. And what that kind of means is that the loud unit owners are going to be the ones that complain the most, bring up the most issues, and might be the most toxic. That's not to make a generalization, but every set of facts is differently, and there could be issues where it could just be an annoying unit owner. It could be a unit owner who is actually dangerous. And we're going to hit on every topic today. We're going to talk about the unit owners who provide criticism to everything a board does, everything a manager does. We're going to talk about a recent case that we mentioned where there was violence in an association in the common areas. How do you handle that? What's your responsibility? We're going to talk about what about in a unit? If someone's concocting a bomb or cooking meth in their unit, what are you going to do there? That's their exclusive space according to your governing documents, most likely. But what can you do? Elderly and senile unit owners, or maybe mental incapacitated unit owners, someone who leaves a boiling hot water on the stove. What are you going to do there? So we'll get to all of that. I'm going to start sharing my screen so we can kind of get into it. And so there's us. And let me start the slideshow. So handling dangerous or toxic unit owners and tenants or residents in condominiums, HOAs, and co-ops. Recent matters and examples. So we're going to kind of get into, as I just mentioned, unit owners with drugs or making bombs in units, fights and flagrant behavior in common areas, elderly and senile unit owners, overly critical or disruptive unit owners. That's basically the ones who complain about every single thing that the board does. Now, I'm gonna go right to Norm. Let's start with the most common example.
Yeah,
Which is,
sorry.
let's start with the most common example, which is someone who complains a lot. What should a board do in examples where there's a unit owner who is just making incessant complaints about everything a board does, complaining about everything, making threats, legal threats, just basically trying to take down the board in any way possible? What are the remedies, or what are ways that a board can handle that type of unit owner?
So this is one of the harder scenarios, because my answer isn't going to be one that I think is well received, because there's not a lot. Unfortunately, there's a case that we'd love to overturn where it gives a homeowner, or says that there's First Amendment rights in association. So owners are allowed to complain. They're allowed to do things. And so in order to get around it, you need to try to be a little creative and try to do what you can do to stifle your normal, regular, everyday complaints or incessant behavior. And one thing that
Jake, can you turn up Norm, can you turn up your?
Yeah, I can try. I just
volume?
saw that. This might be the first time I've ever heard something where somebody's that I'm not loud enough.
Well, that sounds better. But I don't know what you did.
So I moved a little closer, and so hopefully that works.
It seems better.
Okay. So, anyways, what I was saying is, I hope everybody can hear me now. Is it's one of the more difficult situations one can run into because there really isn't a good answer. And like what I was just saying is, there is a case where it says owners have a First Amendment right, meaning that they're allowed to complain. We can't stifle their ability to speech and bring up these issues. However, what we've tried to do is a couple of things. Yes, they're allowed to speak. They're allowed to talk, but they're not allowed to interfere with the board's business relations. So if they're taking the next step further and trying to communicate or dissuade your contractors, employees, agents, then you can get a little bit more involved by way of a cease and desist and possibly a court order seeking to stop this particular type of conduct. However, if it's not that, they're just overloading the board, the property manager, everybody else is what we've tried to do to sort of at least stifle the behavior and make it better for the board to say, look, we can't stop you from communicating, but just because you communicate with us doesn't mean we have to respond to you. So what we've effectively done is said, hey, you're allowed to send these emails, you're allowed to communicate with people, but no one's going to respond to you. You need to send in everything to the counselor or whomever. That person will then compile a list of your questions and we'll get back to you every 4 months, every 3 months at a certain time period to try to take away this instant gratification and try to at least slow it down. Because unfortunately, based on the decision I was referencing, you can't completely stop the behavior as long as it's normal, ordinary behavior.
So Norm, I would take that you're trying to distinguish, because it gets tricky where you have to distinguish the emergency from the why didn't you get more bids? I don't like this. If it's an emergency, well, if the building's on fire, you call 911. You might call the 24-hour emergency hotline if it truly is an emergency. But if it's just, I don't like that the board did this, I think they should do this. I think what Norm's suggesting is that if the board meets every month or every quarter, that you just keep responding to the owner. Thank you for your email. The board will discuss this at their next regularly scheduled meeting. And it sort of puts the brakes on the unit owner so that it's not 5 hours a day or 10 hours a day that the association has to deal with a particular owner, because that could make things very non-cost effective, make the management company want to increase their fees dramatically and make all the board members want to resign.
Yeah.
Exactly. You wouldn't want to stifle any ability, obviously, on the 911 or emergent situations, but Stephen hit the point perfectly there.
Can you get closer to the mic?
Sorry.
Okay, thanks.
Yeah, and feel free to share questions if you have specific questions in the chat or Q&A. And yeah, I think that's something that, I mean, we're dealing with on a few cases. This is the most common one. And usually, yeah, I mean, you hope that you can kind of at least curb the incessant behavior and kind of fear to other unit owners and board members. As I mean, being a board member is a very thankless position. Being a property manager is a very thankless position. And it's hard to get volunteer board members to run, and it makes it even harder when you have unit owners who are just making your every single day painful. So yeah, we if it comes down to it, usually a cease and desist is what we kind of is a good way to filter it out, and that's where we'll get a lot of questions from the unit owner and kind of filter it out, the relevant ones to the board. And sometimes that may be we'll be getting several emails, calls, whatever a day, and we'll make sure to filter out the good ones or the relevant ones. And
let me answer a question that was just put in the chat. Should the complaining disrupting owners be allowed to attend a board meeting to seek that immediate resolve. I'm gonna say that there's probably no legitimate way other than if the behavior at past meetings has been to the point of being dangerous, or the police having to be called in. There's probably no basis for keeping unit owners generally from attending board meetings, but just because somebody asks you a question at an annual meeting of owners, or even at an the open part of a board meeting, maybe have open discussion for 30 minutes for questions, doesn't mean that you can't answer. We will get back to you. We'll discuss that at our next board meeting and get back to you at that. With that, some of the issues are complicated, and we're going back to Norm's idea about that instant gratification isn't the standard. It's responding within a reasonable time and all that. So if somebody asks a question, it's perfectly fine to say, thank you for your comment. The board will be, management will be discussing that at its next regularly scheduled meeting, and period. Next question. Jake, you want to move on to beyond the difficult?
Yeah. Yeah, so now let's kind of discuss a little bit, we'll get into a actual, let's just get right to one of the recent cases that is currently on appeal. A Kettle Brook Lofts condominium case involving a crowbar in the common areas, a fight with a crowbar. And basically what happened here is the rules and regulations have verbiage that states whatever means necessary. What are some measures that can be taken? And this is a pending case, so we don't want to provide, or it's on appeal, I should say. So we don't want to provide, too much legal conclusions as to this, but it is a good kind of case to use as a parameter for what you kind of can do as far as handling either violence or dangerous activity in the common areas of a condominium. So I'm going to push it over to my panelist. What are your thoughts on one, the language of the rules and regulations here, which is pretty broad, but also the fight. Obviously, if it's a one-off fight, there's not much a board or really any unit owner or security could do to stop a fight. If it's someone that has caused fights back, like there's been constant fights, it's going to be a little different. So what are your thoughts on those? Those are the two main points of this case. What are your thoughts to that? And either one of you can take this, Norm or Stephen.
Let me start, if I may. There's again, we talked about we're not giving specific legal advice on this because to get deep into the facts, we don't know all the facts with this case. We know that the lower court did not find a basis for excluding the owner from possession of the unit, but it runs the spectrum from it was allegedly attacked by a crowbar. I think I read that there was the penalty from the courts was 3 years probation, but it gets into questions such as was it just two owners who didn't get along, or two residents who didn't get along, and the answer was for the attacked owner to get a restraining order, or was it that this unit owner was lying in wait with a crowbar for anybody who is crazy world these days, for anybody who stepped out of their unit, so that it was a true danger to others. Excluding a unit owner from possession of his or her unit is an extraordinary remedy. So I think the courts are reluctant to take that drastic a remedy, except in the right case. So they're gonna, I think, bend over backwards to say, gee, we're not going to exclude somebody from from occupying their home even though section 4 of chapter 183A says that you're only entitled to possession of the unit subject to compliance with the documents. The court went out of its way and said, well, there was language about noxious or offensive behavior, and they went to the dictionary definitions and say, well, this didn't really happen there, and sort of blew over whatever means necessary. I guess the ideal solution that I'd like boards to, or managers to start thinking about, and attorneys, is putting in an amendment to the documents that deals with what typically over the last 40-something years has been left out of condominium documents, which is that for appropriate reasons shown, that a board may go into court and seek to have an owner excluded from the premises, obviously subject to the right facts of there being a danger to other residents, etc. So I think somewhere along the way, maybe and I'm hoping on the appeal in Kettle Brook, I'm hoping that the court says, well, they say, yeah, in this case we find it, or whether they say, in some case, somebody's going to step over the line and it will be the appropriate remedy. That's my hope, but I think that an amendment to the Master Deed of Bylaws with something specific as to criminal acts, dangers, etc., may be the ideal solution. What do you think, Norm?
Yeah, overall, I tend to agree with that. And I think, we were talking about this a little bit earlier before we started the call, and that the portion of 183A that Stephen just references, I read it and I think the reasonable interpretation says possession is subject to the rules, but it's not perfectly written that way. I think there's only one outcome, but I can see a judge trying to do whatever they can to not want to go that far, because this isn't a lease situation. It's not an apartment. It's someone's private home. So I think the level is just going to be, it has to be so high. And I think if it's well defined in the docs, you got a better shot to say, well, yes, Your Honor, this is an extreme remedy. However, this person purchased this condominium knowing that he was buying into certain rules and restrictions. And one of these rules were, if you do X, Y, or Z, you're subject to being removed. And, yeah, you can rent the place out. You can still own the unit, but you can't physically live there. I think it would make it cleaner. And the one thing I will say is about these types of situations, and whether it be a fight with a crowbar, whether it be, I've had people where we've had a unit owner threaten he was going to rape and kill multiple people, and things of these extreme natures, where no matter what I would suggest you do as a board under the circumstances is you try to get the order. You try to get the order removing him, and you try to get another order saying that in the alternative that he's got to cease and desist the conduct. At least that way you've done two things. One, if they violate the second part of the order, which is a cease and desist, you have a better chance, I would suggest, on a complaint for contempt to go back and then get an order vacating. Two, God forbid you're in a scenario where you go to court, you have this owner who's making these threats, you attempt to do it, the judge denies it, and then he actually follows through with the threats. Not that you ever want that to happen, at least the board under that set of circumstances from a liability perspective, you did all you could do. You try to get the person out. The judge is the one who stood in your way, and now he or she is going to have to deal with the consequences of their own denial.
Yeah, I think that's a great point, that somebody, God forbid, gets killed or whatever, and the person who suffered the damages sues the board and the manager and everybody else. The answer is going to be, hey guys, we went to court, we attempted to get an injunction. The judge, for whatever reason, didn't award it. We took all reasonable steps to deal with this issue, and the judicial system said that the owner was not going to be excluded from the property. There's one more argument that you put into the, I guess, into the arrows of the quiver, or whatever the expression is. In landlord tenant law, there's a provision that says, so it's very difficult to evict a tenant. and summary process, and it's just fully in favor of the unit, of the tenant in Massachusetts, and has been for years. But there's a provision that says versus the long process of summary process, which is a long process, you can't do it without a court order to get rid of a tenant. But there is a provision that said if there are drugs, gambling, or prostitution, that those are immediate reasons for a shortened process to get rid of the tenant. And I guess my argument, and interested in Norm's thoughts, would be why not raise with the court that, Your Honor, we have, if this were a tenant, the conduct, if the person is selling drugs, involved in prostitution or gambling, there'd be like an almost immediate ability to get the person out. Why should the remedy be less just because it's a unit owner who's involved in those illegal activities? No?
Yeah, and I think that's one of the better arguments that you could make on the side. You know, in the end, though, I do think there's going to be a look at it. Well, in the end, this isn't a tenant. This is the owner. So I think there is going to be a higher standard typically set forth. I think it's the closest thing you can compare to, and I think in the landlord tenant situation, you're almost buying into that type of an agreement. They see it more, whether or not it should or shouldn't be the case. I think that's how it seems, at least to me, that the courts are interpreting it. But I think that is a way to try to maybe swing the argument more, or maybe the best place to bring these types of cases is in housing court and not superior court, because in housing court they're more comfortable or used to the removal or evicting of tenants. And you know, there is that argument that we can say really it's no different. The threat here of the drug use is there, and it or the bad conduct is there, just like it is if the actual owner is doing it.
And I don't think the housing court covers every jurisdiction, but there's housing court in Boston, there's a Southeast region housing court, but all they're hearing are landlord tenant cases every day, so they're going to be totally familiar with the exception as to drugs or prostitution, and might make the connection a little bit quicker. So that may be that may be worth pursuing.
Great. And something I want to kind of touch on, because we're kind of skating around it, is what is, you know, as a board member or property manager, you're not expected to be a police officer, you're not expected to be a security force. So we want to get into another case called the Field case, and this was a double homicide case in South Boston that involved an instance where two doctors lived in a penthouse in South Boston, and another person was able to get access to the penthouse floor and get into the units and commit a double homicide. Now, in that case, there was a decent amount of foreseeability, reasonable foreseeability, and as you can see here, boards and managers' duty of care. What is the duty of care? If there's a reasonable foreseeability as to the issue, then that is kind of an instance where you'll have to act. There's ways to get proper security in place. We did do a Marcus hour on premises security, and we have done or we have discussed kind of ways to the police are there for a reason. If you need to make a police report, it's good to have that documented as well in extreme instances. So again, let's kind of touch on that a little bit. As far as one, what can you do as far as implementing the proper security? I mean, that we could have a whole webinar on just implementing proper security. But one, what can you do to make sure you have the proper security and measures in place? And two, what are your duties, or what should you be doing? You're not going to be able to monitor every single thing that happens in an association. That's just that wouldn't be possible. And I want to bring up one more case, Surfside, the Champlain Towers collapse. Actually, it kind of ties in here because it involved the front desk has a state-of-the-art security system, and the backdrop of that is there was a $1.2 billion settlement in that case, in the instance where 98 people unfortunately died in a due to issues with the building. And in that case, there was a $1.2 billion settlement. Half of the settlement was paid out by the security company or the security company's insurer. And in that case, the security company was found to be on the hook because there was a state-of-the-art button that they could have pressed that would have allowed 7 minutes for people to evacuate, and it was not pressed. So again, that's something where it's kind of having the right security in place, but let's get into kind of what you can do as far as preventative measures, not just in the governing documents, but as far as taking action when you see something happening.
And if I can stick on this slide for a second, one of the things that will help possibly in a number of these cases, especially in the field, double homicide, is there are security risk consultants. And again, the same idea as a court not issuing an injunction against a dangerous unit owner, you shift the liability. If you bring in because you're not security experts as volunteer board members, but if you bring in a security risk manager and have them go through your procedures, in the field case, people were getting into the garage whenever it opened, like kids, and damaging like very expensive cars. And then they were able to get into the building and then up to the steps to the penthouse, even though the penthouse owners, the two engaged surgeons, had their elevator fob only, they're the only ones who get to their floor, but they were finding people in the hallways, and it was because the stairwell doors were open, and they complained several times about people being there and security concerns, and it was ignored. So that didn't help in that case. But a security risk manager may be able to give some give you some good ideas to bolster your procedures, but two, it shifts the liability if you follow those recommendations to what the person says. No?
Yeah, and I think Fields was a little more unique in a way than some other condos, in that there was the specifics in the management contract and in the governing documents, which had some security requirements and then some duty to do that, which aren't in a lot of documents. And I think what Stephen pointed out there was good, with not only with respect to the security aspect of it and looking for some outside source to really tell you what it is, but also Field specifically dealt with a known issue with existing elements. So I think one of the takeaways is, if you know there's something wrong with your current setup that's allowing third parties to enter the building or allowing violence to occur or other crimes, it's time to take action. The question about the reasonable foreseeability is a little different, in that most of the cases on it are involving landlord tenants or house parties, where it's like, well, you let this party happen. You knew in the past when it's happened, such and such conduct has happened. So you knew if you did it again in the future, it could happen again. And the line becomes, where is the line? Some courts have said, well, drug use at the properties, not enough to know that a violent act would happen. You need previous violent acts to happen. So it's an interesting aspect right now. And I know there's some questions, like in certain cases, where do you need to add elements to make sure the security is appropriate and to prevent from third parties. And I don't know that that's the case. But I think the key takeaways are, you need to know what your issues are. You need to make sure that your existing elements are functioning as they should be, and that they're working appropriately. And there's sort of I wouldn't call it a contrasting case, but I think it's an interesting case out of Georgia, where it was a gated community. The gate was broken. somebody took advantage of the broken gate to get on the property that they weren't allowed to be there, and they shot somebody. And the person they shot sued the association. The court ultimately said, well, look, in these documents, there is no duty to provide security, for one, and two, the broken gate, the board knew about it and was acting to fix it as soon as possible. And while this Georgia case doesn't necessarily have any application up here, I think it gives you a good idea that if you know of a defect and you take advantage of it and you're trying to fix it, as long as you're doing it as reasonable and as fast as possible, you're probably putting yourself, at least in the best case, that you can be under the circumstances.
And the one helpful hint that may help, that may not, but it goes back probably 30 or 40 years, is when certain condominiums started to be much more prevalent in Massachusetts, was that people would have security guards and they'd be advertising, we have security guards. And even though it may not seem significant, the advice back then and still is, well, gee, are these people security guards or are they just concierge? Because security guards puts the level of expectations and duty to a higher level. So a long time rule is if it looks like security and whatever, maybe it doesn't matter what you call it. But in a lot of cases, we just told people stay away from saying security and have concierge service that maybe helps a tiny bit. Do you want to go into the other slide with the remedies, Jake? Or did Norm want to talk about tuck point for a second?
We can.
Tuck
That's
point
actually
is the one. I think tuck point is the one.
concocting bombs.
Well, in Beverly, Mass was the one case with the bombs where I think it may have crossed the line, but
So let's before we get into that, and that's a good segue, because I think that's the next kind of sub segment of this that we can discuss, is not only tuck point, and we'll get into the background of it, but basically it's someone who was making bombs in their unit or concocting bombs in their unit. I don't know the difference. What's the difference, Stephen?
I don't know what concocting bombs is. I think of concocting as like making a cocktail.
Oh, okay.
This isn't legal advice. We've given a
And don't
disclaimer.
Google it.
I thought your use of the word concocting was odd, and other than working for you, and you were a wonderful boss. I've also heard that you're related to me, so I can say, why are you using a stupid word like concocting? But anyway.
Anyways, so tuck point, they were concocting or making, I guess is the proper word, bombs in a unit. I mean, that's definitely a danger. That's obviously an issue. What do you do there, though? What do you do with that? What do you do with a unit owner who's making drugs in a unit? We did get an interesting question, a good question, as to civil rights, basically, of unit owners and the right to privacy. What about or even, high powered rifles or firearms? I mean, if you have a right to carry, then yeah, what is the unit or what's the board's right to kind of preclude that from happening in your
Can I answer that, because that came in a week ago?
Yes, sir.
By a CPA who might be on the call. There's a big difference between and what do we have, those dunk bombs or whatever? What was the recent Supreme Court case? But basically, there's a difference between a right to carry and so let's say that carrying a gun with a permit is legal. That does not mean that you could go out with a gun or a rifle and stand outside the building and threaten residents as they walk by that you're gonna shoot them. That the legal activity becomes illegal once you take the step of assaulting somebody. So I think we're going totally off track if we go into the debate about assault rifles and this recent U.S. Supreme Court case, which clearly said that machine guns are not legal. And the feds in the states have bounced back and forth on assault rifles. But it's not the question of that distracts the issue from, it's not the question of somebody having a permit for a gun or Second Amendment rights. Even though the federal government has said no machine guns, so with no problem with Second Amendment rights, the real issue is the improper use of the gun. In other words, nobody would know that there was a assault rifle in somebody's home. The issue would only come up if the person used it to attack owners. Once you attack owners or residents, I think is where you've crossed the line, even though it might be a legal activity. So I just want to, I don't think it's a Second Amendment issue. It's a question of not the gun being legal or not legal. It's the unit owner engaging in criminal acts with that legal
Yeah.
gun.
So
Yeah,
yeah, like
Steve, and I can give you a good example of that even takes it away from the Second Amendment. Is I had a case a few years ago where we had an owner with the bow and arrow, and no one cared about the bow and arrow. It's not even, it's not, there's no real debate about possession of a bow and arrow. The problem was he kept pulling out the bow and arrow and aiming it at people he didn't like at the association. There's your example, I think, right there. And we brought and got a court order. He was a tenant and he was ultimately removed from the building. But there's the line. I don't think anybody would have a problem of you owning your simple bow and arrow. But when you started aiming at other people in the common areas, it turned into a real problem,
Yeah.
whether or not he ever intended to or accidentally let it fly. That's the problem here. It's not the possession, it's the use or acts.
And my suggestion to cut the discussion short on a flurry of Second Amendment questions is, if the person posting this as anonymous wants to call me and discuss for 10 hours Second Amendment and what kind of guns and rifles is the government allowed to prohibit. My cell phone number is 781-413-5226, but I think we're taking people off the course of what this program is about if we start getting into a Second Amendment issue. This isn't civil liberties issue. This is somebody who's using a gun to hurt people. And I don't think we should spend another minute on it, but I'll spend hours with the person who posted the question if they want.
Excellent. But I guess that's a good segue. All right. So, I mean, I've also dealt with an issue where a landlord had a tenant who had a firearm. Clearly there was something off because the person ended up he's, according to police records, his dog told him that the whole apartment complex was out to get him. And he needed to shoot through every wall in his building. He did. Luckily, no one was injured, but a very scary incident, as you can imagine. Now, that's an extreme. Again, we're not going to get into the civil rights and Second Amendment rights, but what about a elderly or senile unit owner? Or what about someone making drugs or bombs?
Just to go back for a second, was the dog charged with anything in that case?
I think the dog actually, yeah, it was Scooby-Doo, and he had to.
Carry on. You were going to another topic.
And I wish I had Digby today. So elderly or senile or unit owners who are a harm to themselves potentially. What do you do in those instances?
So I had that case back with somebody who then became a housing court judge, and it was based on a persistent but very, very bright property manager by the name of Robin Hanson, who was also one of the founders of the New England chapter of CAI, and he would do one property at a time. So one of his properties was a very expensive high-rise on Beacon Street in Boston. And The building was gas fired, and Mr. and Mrs. Smith who were elderly and senile and dementia, would put their tea on and forget that it was on the stove, and it would set off the alarms throughout the whole building. Fire department would come and all that. They were the nicest people, but and the other problem they had is they used to pay their condominium fees once a week, uh, which I guess isn't a problem. They forgot that they had paid. It's sad, they forgot that they were paying, so they were paying every week. We try to reach the family. We try to deal with elder services, and finally we brought the case in housing court and said, we don't want to do this, but these people are either going to kill themselves or everybody else in the building. And the judge was so compassionate, and because the people had money, actually ordered that he didn't go to the extreme of excluding them from the unit, even though that was our request. He said he required that a home worker go in who had keys to the oven and stove, prepare the meals, and then lock the stove and oven when they left. And these people had the money to pay for that. And that was a excellent and compassionate decision by the judge of how to deal and take away the danger. But there are some very sad stories where people are dangers to themselves and others, and you have to deal with it. So at all times, be compassionate in terms of how you treat people either with dementia issues or mental health issues. That's about it on the boiling water. But when we started with the conversations with the manager, it was, oh, Robin, that's crazy. You can't do that. And well, why not? And that was the case of the property manager, as usual, being much smarter than we were as attorneys and convincing us that we could go in and give it the best try, and we got a good result.
Excellent. Yeah, and I think that's something that whatever the issue is, each set of facts is going to be different. How you're going to deal with something that's in a unit versus not, and this kind of just goes back to the same thing. When to intervene versus respecting unit owners' rights / privacy. Yeah, it sometimes is a judgment call. You need to get the right experts in. You're not expected to be a trained security force. You can't just break into a unit if you suspect something's going on. Yeah, and let's kind of, I want to get into kind of the biggest metric is, and again, we are getting a lot of good questions. We will get to those. If we don't get to them during the program, we will get to them after. So the biggest thing that we've kind of touched on here and there is there 183A, 718 in Florida, whatever statute you have that relates to the Condo Act, there are certain kind of conditions where you can fine unit owners. That's usually one of the most simple, and sometimes you can go through a due process hearing, what have you, as to the rights to the fine, usually $100 a day up to $1,000 for certain fines. What else can you do? What can a board member, what can a manager do beyond fining the unit owners? And we touched on, what is your right to evict or foreclose? It's a little trickier. Kettle Brook Lofts. It's more of an interesting case because when can you boot a unit owner? What would be the instances? Well, we don't know that yet. There really is no specific case law that has allowed the allow to basically foreclose on a property, short of you know, if you keep fining someone and basically forcing their hand to not pay a certain amount. So if you keep fining them, then they go through the collections process. They don't pay their fines or their dues that latch on with attorney's fees, and then you can foreclose. But that's a whole process. As far as just quick and easy, it's not. There's not a condition like that. So what can you do? There are ways to suspend voting rights in certain instances. There are ways to, let's say someone is a nuisance at the pool area or the gym. There might be, depending on your governing documents, certain rights to restrict amenity or common area usage. And again, another thing we touched on was a court order to remove an owner. That is a possibility. But again, it's not just an easy open and shut eviction foreclosure process. Other kind of just prophylactic measures that you can kind of put into place are documents amendments and resolutions that basically provide more teeth to action. This and Norm and I were talking the other day about kind of background checks. This is a very custom and common practice in Florida to have background checks as it relates to incoming unit owners, incoming tenants, and having the right to deny. Usually the denials are based on, let's say, financial or income related issues. If they don't provide bank statements or something of that nature, there is technically a right to refuse if you have it in your governing documents as it relates to an incomplete application. I don't think that's too common in New England, nor would we necessarily encourage it. But it is a measure that has been used in other jurisdictions, and if it's in your governing documents, we wouldn't say, I mean, yeah, there's no restrictions as to doing it. That said, I would proceed with caution on that. Directors and officers insurance, that's just important to have as something as a protective measure across the board. But yeah, these are some of the kind of area. What else would you guys add to what I'm kind of getting at here?
Well, I was gonna try to pick off at one or two of the questions. There's one about, isn't this for the police and not our problem? Unfortunately, the answer is no. I mean, if there's a dangerous activity or unit owner at your property, you can certainly call the police. You can certainly speak to your attorneys and get various measures of what you can do. But if there's, for example, in the two surgeons case, if there's negligent security because people can just walk up the staircase and get to that to the penthouse floor, that's not a police issue. That's an issue of the board of manager have some obligation to see that the potential for crime in that case was foreseeable and take measures to stop it. The other thing that was mentioned is a nice comment about that somebody's saying a lot of mental health issues, and they are very sad. But then the person ends with, there's not anything that can be done. And I guess I disagree somewhat with that. And again, we start gently. So contact the family members if you can find them. Contact elder services or mental health service agencies. And even and if you then need to try a court order or other enforcement, do it in a compassionate way that we don't want to do this. The person has a disability, but the actions of the owner are a danger, puts the residents in the building in danger. And so I think some steps have to be taken. And add to that, the bringing in the security risk management consultant to do an assessment of the property for potential issues might help. No?
Yeah, and I think I agree with that, and it's also something we touched upon earlier. If it's just the people that are pegging you with issues and complaints that aren't necessarily condo related, I think that's part of it, and that you have to just stop the instant gratification at some point in time. If it's the separate issue, obviously the mental health part of it's important, and if there's a way to contact the family and stop anything, that's great. But where it's not possible, it might just mean that you have to sort of do your best to take a deep breath and just say, look, we're going to respond at this point in time, the end. And I honestly, you can respond every time, say that, or you can just ignore the person and get back to them on a monthly or quarterly basis to kind of show it by example. This is how we're going to handle this situation because you're overrunning the board and overusing our use resources. Excuse me.
Yeah. And I think that kind of the last question we kind of put on this is what we kind of started this with is the biggest issue that comes up that we see the most, or I should say not the biggest, but the most common one that we see is what can there 183A is designed, and 718 in Florida and other Condo Act statutes are designed to actually provide for very specified delineated items that you can request from a board. What you have a right to, which includes financial records, which includes the governing documents, which includes certain other measures or metrics. Now, Norm and I are handling a matter right now where the request that we recently got is it basically just cites the 183A in Massachusetts as to financial records requests. And that is a relevant question. That is one that we can comply with and that we have a duty to comply with. Other questions as to, what are the licenses of the board member? Just hectoring questions are not necessarily relevant, and other things that they'll ask as to just random things that are basically a stream of consciousness requests. What do you do in that instance? So I think that in these instances, as far as a request, the statute should be in line with what you can comply with, what you don't have to comply with, or what basically is irrelevant, and noise. And yeah, if it's obstructive, it gets into, there is a question as to suing if one unit owner sues another unit owner. Technically, I mean, I think who would have to, it says you would be suing yourself. I think in that instance, if it's a derivative lawsuit by the unit owners against a board, and then insurance comes into play, there could be the issue of double attorney's fees. But when one unit owner is just causing so much of a ruckus, and it's causing a lot of attorney's fees to be spent, yeah, you don't want to have to just basically deal with that and the payment of that. So that's where you kind of can push back and say, all right, cease and desist. We will comply with relevant requests, but again, that may come with costs, and it might not be an issue that goes away completely. Other issues that involve common areas, other issues that involve units and the usage of units, and the rights to privacy, that's going to be a little trickier to impede on. But yeah, I think we kind of hit on the major areas, which are: one, disruptive, constant request, common area if there's an issue going on, and violence in the common area. What's going to happen with the Kettle Brooks case, and kind of, can that be used as guidance for future Stephen mentioned if there's possible issues with where's the line, and what's going to cause the rights to further action beyond fines, and then in a unit, just protecting the well-being of all unit owners, and dealing with dangerous owners while also respecting unit owners' privacy rights. We're happy to answer any specific questions, and I know we didn't get to all of the questions in the chat, but we appreciate you coming out today on a Friday. It is the Celtics parade day. Congrats to them. It's been a good year for our sports teams. Norm is a Michigan Wolverine fan. And with that, we thank Norm for joining us today. Any final words from the two of you hooligans?
No, if you can cut and paste the chat, the questions, Jake,
Yeah.
we'll send you next week, the PowerPoint.
Next month.
the
Next month.
Next week.
What's next week?
Next week, we send the
Oh, we'll send.
attendees.
Oh, I thought you said we'll see you next week.
No. Isn't it July 4th? Or close? No, we'll send you next week, the PowerPoint, a link to the program, to the video, and answers to the questions that were in Q&A and chat, and questions that we got prior to today. And I think just want to thank everybody for attending, and keep cool.
Yeah, keep cool. Enjoy July 4th. And yeah, make sure to check out the Celtics parade today.
Yeah, thank you, everyone. I hope everybody has a great weekend. It was a pleasure to be here and take part of this, and I'm sorry for the microphone quietness. It's